New TCPA updates you should know. Key court rulings, FCC changes, and compliance risks. Here's a breakdown of the most important updates and what they mean for your compliance strategy. Watch until the end to find out. Let's get started. TCPA update number 1. Court rules text messages aren't calls under D&C rules. In Davis v. CVS Pharmacy, 2025 WL2491195 case, decided by the U.S. TCPA Court for the Northern District of Florida on August 26, 2025, the Chief Judge for the Northern District of Florida ruled that text messages are not considered calls under the TCPA's Do Not Call provisions. Key takeaways. The court applied a plain language reading of the statute. This ruling only affects D&C-related cases, not ATDS claims. It's the second court to reach this conclusion, hinting at a possible trend. TCPA update number 2. ATDS claim survives in Oklahoma case. In a separate case, an Oklahoma district court allowed an ATDS or automatic telephone dialing system claim to move forward against a debt collector. The plaintiff alleged the caller ID failed to display a name. There was a noticeable delay before an agent joined the call. Why it matters? Operational issues like agent connection delays and missing caller ID data can still lead to lawsuits even if your technology isn't technically classified as an ATDS. TCPA update number 3. FCC finalizes definition of prior express written consent. What's changed? So one-to-one consent rule requiring consumers to grant permission to a single seller is officially removed. Final definition. An agreement in writing bearing the signature of the person called that clearly authorizes the seller to deliver advertisements or telemarketing messages using an ATDS or pre-recorded voice, and includes the phone number where messages may be delivered. Why it matters? Lead generators can no longer rely on blanket disclosures or partner lists. Sellers must ensure that signatures clearly authorize their outreach. TCPA update number 4, called Party, Defense Weakens in Wrong Number Class Actions. In Massarello v. Power Home Remodeling Group, 2025 WL2463153, case decided by the U.S. District Court for the Eastern District of Michigan on August 27, 2025, the court rejected the intended recipient defense, creating higher risks for wrong number calls. Why it matters? Businesses are liable if they contact a reassigned number unless they verify ownership first. Tools like a Reassigned Numbers Database API can help minimize this risk. TCPA update number 5. The FCC cuts off 1,200 plus non-compliant providers. The FCC has removed over 1,200 voice service providers from its Robocall Mitigation Database, effectively blocking them from the U.S. telephone network for failing to comply with anti-robocall requirements. Providers must implement stir-shaken caller authentication technology, maintain robust robocall mitigation plan, submit accurate certifications to remain listed in the database. Those that failed to meet these obligations were cut off, with their traffic blocked unless they gained FCC approval to rejoin the network. TCPA update number 6. Plaintiffs can't invite calls and then sue. In Clemens v. Consumer Solutions Center, a case decided by the U.S. District Court for the Eastern District of Virginia on August 22, 2025, the court ruled that a plaintiff who requested information about products cannot sue for follow-up calls directly related to that inquiry. Takeaway. Calls made after a consumer's inquiry are generally protected under the established business relationship exemption. That's all for today. Want to be updated with the latest TCPA news? Like, comment, and subscribe to our channel for more. See you in the next video.